So what I'm going to be talking about today are what I call epistemic reparations and the right to be known. I think both of those will become clearer as I kind of work through some of the materials. So I want to start by just situating this within some testimony that was given to the South African Truth and Reconciliation Commission. So as many of you probably know, the South African TRC was established in 1995 to investigate human rights violations that took place under apartheid. And Lucas Baba Sikwapere was a victim of apartheid-era violence, and he came to the TRC to provide testimony. And while he was giving his testimony, he recounted having been shot multiple times by an apartheid-era police officer, which led to multiple bullets being lodged in his neck and face, which caused blindness and continue to cause severe headaches. And when the commissioner asked him, "How do you feel, Baba, about coming here to tell your story?" Sikwapere responded, "I feel what has been making me sick all the time is the fact that I couldn't tell my story. But now it feels like I got my sight back by coming here and telling you the story." Now, of course, Sikwapere did not literally regain his sight by testifying to the TRC. Instead, he's communicating that something powerful or transformative occurred through the act of telling his story. But notice that telling is here being understood not only as distinctively interpersonal, it's also a success term. It's clear that Sikwapere would not have had the experience he had if he told his story with no listener or if the audience members ignored him. He didn't want to just utter words into the void. He needed to be listened to and heard by other people. Otherwise put, Sikwapere needed to be known in order to feel like he got his sight back. And I'm going to obviously spend a lot of time talking about what I mean by this, needing this to be known. Now, one thing that's really interesting in, I say these cases because in the material that I'm going over today is part of a book that actually I think was published March 5th or 6th, so it's off my desk. But in the opening of the book, I talk about a lot of different cases. I talk about testimony that was given at a commission in El Salvador, in South Africa. I've done a lot of work in the last few years in Canada with residential school survivors, and I do a lot of work with people who have been part of kind of the carceral system in the United States, and obviously more specifically in Illinois, which is where I am, and have experienced various forms of carceral injustice. So the cases that I'm particularly interested in, and I discuss a broad range of them in the book, the being listened to is not purely instrumental in them. Rather, it's an end in itself. Now, of course, reporting gross violations and injustices is often a means to an end of preventing these same abuses from happening to others in the future, or educating the public about atrocities, and so on. But in the above case, Sikwapere is highlighting the need or wish to be known as independent from these other aims. And one of the things I do in the book is I look at some cases. This is not to say that everyone who came to the South African TRC came so that listening could be an end in itself. People came to provide testimony for a whole bunch of reasons, right? But some of them are cases where the listening is an end in itself. So I'm not making a claim that everybody who provides testimony at TRCs is doing this. Now, in a 2005 update to a report that was originally issued in 1997, where the report was addressing the impunity of perpetrators of civil and political human rights violations, the United Nations Commission on Human Rights maintains that, quote, "Victims and their families have the imprescriptible right to know the truth about the circumstances in which violations took place, and in the event of death or disappearance, the victim's fate." The UN claims that it's an inalienable right of every people to know about the perpetration and circumstances surrounding heinous crimes. Now, these two aspects of the UN's report concern the right bearers, right, the people who have the rights, and the nature of those rights. But there are also corresponding duties of the states or governments, or just broadly the perpetrators in question, that the UN talks about as well. So the UN talks about the state, for instance, in these kinds of cases of state-sanctioned gross violations or injustices, that the state has the duty to make knowable. Okay, and there's various things that could go into this, one of which might be, for instance, the duty to preserve memory. And this can involve, for instance, the preservation of archives and other evidence concerning violations of human rights and humanitarian law. It can involve the facilitation of knowledge of these violations, including, for instance, protecting the collective memory from extinction, guarding against the development of revisionist and negationist views, and so on. Now, there are 4 features that emerge from the UN framework, and I'm going through a lot of material really quickly because I want to get through a lot. And I'm happy to spend more time during the Q&A if you want to hear more. So just to kind of situate the project, I take as a starting point looking at the UN's development of this right to know. So classically, for instance, in a case of genocide, the UN is particularly interested in, for instance, victims, this is just an example, like a victim knowing where the body of her husband is buried, right? Who was involved in his murder? Was the state involved? Is there a cover-up? So the UN wants to say, in these sorts of cases, this victim has the right to know, okay? And this is a right that that arises from the gross violation or injustice, okay? So I've been talking about epistemic reparations and the right to be known for years. I've been working on this book for a number of years. And I often get the question, well, do we just all have the right to be known? Do I have the right to be known, by him or by her? And in fact, I was giving a talk one time, and even during the Q&A, someone didn't like the way someone else talked to him, and he later said to me that he had the right to be known, not as the way that this person was. That's not my view. Maybe that there is such a right, but I want to be clear that I'm interested in rights that arise out of gross violations or injustices. Okay, and so this is where I'm starting from this framework of the right to know, and the project is going to argue that we also have the right to be known. Okay, so right now I'm just situating this in what the UN actually says the rights are. So these are some of the features that emerge from the UN framework that I went over extremely quickly. First, possessing certain kinds of knowledge is a right, and it's a right that belongs to individuals and communities. Secondly, that there can be a right to something that's distinctively epistemic in nature, which is a bit unusual when we talk about rights. I mean, there are certainly rights to things that are distinctively epistemic. I'm not saying that this is wholly unique, but it's just significantly rarer than the kinds of rights that we typically think about, which involve much more, things that are more in the moral and political realm. The right in question here is regarded as an inalienable natural right, one that is not dependent on law, culture, or government and can't be repealed. And fourth, the right is connected to gross violations and injustices, often those that are perpetrated by states, governments, or groups. Now, one of the things I argue in my book is that this framework from the UN is powerful not only for what it includes, but also for what it leaves out. So as I already kind of gave you the preview, I argue that that absent from this picture is another dimension of rights and duties that is arguably just as significant as those highlighted in the UN report, and that's what I call the right to be known and the corresponding duty to know or to see, hear, bear witness, and so on. Okay. So I'm just going to quickly go through some contrasts between these two rights. The right to know involves a knower and a proposition or propositions, and so it need not be interpersonal. For instance, it can be, and often is now, fulfilled by making available, this is like what happens a lot when body cam footage is just released to the public, right? Information is just made available through video footage impersonally captured, and those kind of what that footage captures are certain facts or truths, right, that are just made publicly available. And in many cases, body cam footage is released precisely to satisfy the public's right to know. A community is outraged by something that happened, right? And so the state, releases the footage to say, here you have a right to know this. In contrast, the right to be known is an overtly interpersonal phenomenon, given that it doesn't make sense to be known by an impersonal object, Being known requires at least two persons at the most fundamental level, the knower and the one being known. I should clarify, like, I'm not thinking of persons necessarily as being limited to individuals, right? Individual persons. Like a person can be a group, a person can be a collective. It just can't be a non sort of, an entity that has, kind of is not connected to consciousness at all. The right to know has the corresponding duty to tell. So since people have a right to know about gross human rights violations, for instance, the state has a responsibility to do things to enable the creation, preservation, and transmission of knowledge. Here, there is the implicature of at least partial ignorance on the part of those most harmed. That is, victims, their families, and communities have a right to know about gross human rights violations, so the state has the duty to investigate, remember, and archive so as to uncover and make available what really happened and who was involved. The right to be known, in contrast, has the corresponding duty to hear or know. It is not just that people have a right to know what happened to victims in certain contexts, it's also that these victims themselves have a right to be seen and heard or to have their stories be given proper uptake. There's no implicature here of ignorance on the part of the victim. They don't need to be given access to truths or facts. Instead, they need to be able to be givers of knowledge, and this requires the listening of others. So honestly, I can't even remember everything that I have on these slides because I have a lot of different there's a lot of different material in the book. But I mean, I think that the right to be known is justified through a multitude of different kinds of mechanisms. So, one, for instance, would be being a contributor to the historical record. That sounds a little bit more instrumental. But in the book, I also talk about some of the distinctively epistemic benefits about being known. And the wrongs that they are repairing. Some of this will come out, I know for sure in this talk, but I also kind of want to say that I'm happy to go over all of this in more fine-grained detail in the Q&A if that would be helpful, because I'm doing some of this at a bigger picture. So one of the things I argue is that the UN's framework for understanding the right to know can and should be crucially expanded to include the right to be known. So I frame both the right to know and the right to be known within a framework of what I call epistemic reparations. So first I want to talk a little bit about how to understand reparations more generally. So here's just a standard conception that Margaret Urban Walker gives us. So she says that they are intentionally reparative actions in the form of goods given to those wronged by parties who acknowledge responsibility for wrongs and whose reparative actions are intended to redress them. Now, standardly, reparations are said to have, broadly speaking, one or more of three different kinds of aims. The first would be like legal and political, broadly speaking. This would include things like the restoration of citizenship and liberty, the reinstatement of jobs and benefits, the restitution of property, ensuring public status and recognition, and so on. The second would be psychosocial, including relieving suffering, distress, anger, powerlessness, and the sense of violation experienced by victims and their family members. The third would be moral, including recognizing and restoring the dignity of victims and reaffirming or reestablishing the moral order of a community. But one of the things I show is that absent from this picture is a dimension that is just as important as some of these other ones. So we can be wronged not only legally and politically, psychologically and morally, but also epistemically. We are members of an epistemic community in addition to a legal, political, and moral one. We're not just agents in a political and moral sense, but also an epistemic one. And we have epistemic duties distinct from our legal and moral obligations. I'd say maybe the last, 15 or 20 years of social epistemology has been arguing for various of the claims up here. Some of my work has contributed to this, like my 2023 book. I mean, I spent a lot of time talking about a distinctively epistemic kind of wrong that's perpetrated by the criminal legal system, for instance. But I would say that what I take to be the original work of the project is not defending any of these claims exactly, because I think that social epistemology has been doing that for a while, has been defending a lot of these claims. I take a lot of what I'm doing is focusing on the reparative work that needs to be done with respect to these kinds of epistemic wrongs, and fleshing out a specific kind of reparation under the heading of the right to be known. So 2 ways, broad ways, this is not exhaustive, of not being known that epistemically wrong might involve invisibility and vilification and demonization. So I'm just going to go through, some of, how to understand these very, very, broadly. So if I don't have any relevant beliefs about you because you're invisible to me, especially as a person, then ipso facto I don't know you. The narrator in Ellison's Invisible Man says this pretty powerfully. White people refuse to see me. When they approach me, they see only my surroundings, themselves, or figments of their imagination. Indeed, everything and anything except me. And then vilification and demonization involves replacing the image of a person of the person in question with an inaccurate and vilified or demonized version. So one of the things, let me see what I have on the slides. Yeah. So I think that we can think about again, I work a lot in the space of incarceration and the criminal legal system. So I spend a lot of time in the book developing how, particularly with respect to Black men in America, we see both the invisibility and sometimes what's called hypervisibility, right? So within, when we look at kind of over-policed communities, for instance, there is a kind of hypervisibility of kind of seeing particular community members in a vilified or demonized way. And then there is erasure with respect to kind of other dimensions of social life where we would see that on the invisibility side. So again, none of this part of the project do I regard as kind of is adding to the literature in a way, because all of these sorts of things have been very well developed, not only in philosophy but across the social sciences. So one of the things I develop is a notion of epistemic reparations that would be something that is owed to people who are rendered invisible or vilified or demonized in ways that either constitute or arise from a gross violation or injustice. Okay, so I'm going to give you, I'll kind of go through that a bit, but first let me just give you the account of epistemic reparations that I defend. So I understand epistemic reparations as intentionally reparative actions or processes that aim to restore, co-produce, or create epistemic goods for those who have been epistemically wronged by parties who acknowledge these wrongs and whose reparative actions are intended to redress them. So I want to just kind of highlight a few dimensions of this account that differ from the account of reparations that, just the general account of reparations that Margaret Urban Walker gave us. So the first is that Walker's account talks about not only acknowledging the wrongs in question, but also taking responsibility for them. And so she's really thinking about reparations as being the sorts of things where there are kind of perpetrators and there are people who have been wronged. And I do not think of epistemic reparations that way. So I think that epistemic reparations simply have to be the sort of thing where the wrong is acknowledged and the actions are intended to, kind of to redress those wrongs that are being acknowledged. But there doesn't have to be any sense of acknowledging wrongdoing, because I think that, for instance, as you'll see maybe later in the talk, I think we all have the obligation to engage in reparations. And so I don't think that this is something that only needs to be done by people who have engaged in the wrongdoing. Okay. I also removed language about the goods being given to someone, because that sounds like a very sort of passive, sort of goods are just kind of handed to somebody, kind of here's, your land back, right? But I think that when we're talking about epistemic reparations, there's a lot of different ways we can understand this. And so the processes, well, that's another thing that I focus on is I don't think that, well, let me just focus on the second part first. I talk about the aims being to restore, co-produce, or create epistemic goods. And so I think that these are goods that may be brought into existence through collaboration. One whole chapter of my book that I'm not going to talk about today, but I talk about co-constructed narratives. So how there can be narratives that are co-constructed through both telling and listening, right? And when there are appropriate listener responses, I draw upon some work in psychology, but also in philosophy, to sort of develop this count of creating these sorts of narratives that didn't exist before. And so it's not something that kind of existed, was taken, and then was returned, right? There are goods that can be completely, kind of created or co-created that could be part of the reparative process. I also move away from what I call an act-based conception of reparations towards what I call a process-based conception of reparations. So the kinds of gross violations and injustices that I'm interested in are not one-off wrongs. These are not the sorts of things like I use in the book an analogy of, kind of like how I steal your car, you were without a car for 2 weeks, you missed 2 weeks of work, right? And now we calculate what I have to give back to you to make you whole, right? In a lot of the cases I'm interested in, there is no making someone whole in an act like that, right? And so I think of the wrongdoing of many of these cases as being an ongoing process, right? A lot of the kinds of gross violations and injustices that that we're interested in have ongoing wrongdoing, kind of that is continuous. And similarly, I think that the way we need to think about repairing those wrongs is similarly a process-based. So this is not, I say throughout the book, this is not a one and done, right? It's not like we just kind of do this and we're people are whole, right? And so I replace the traditional conception of reparations where it is an intentionally reparative action with, it's an action or a process, right? Because these are a lot of the cases that I'm interested in are processes. So those are just some of the differences with the conception of epistemic reparations that I'm defending with the more traditional conceptions. Okay, so the view I defend is that in cases of gross violations and injustices that involve not being known, so let me just pause and kind of like, put those two things together. As I said at the outset, I'm only interested, maybe this will be helpful too. I'm not thinking of the view I'm developing as a view of what we may call epistemic repair. So another question I've gotten over the years is, well, I feel like when people interact with me online, I'm not properly known, right? People are just like, it's hashtags and you know what I mean, like horrible comments and whatever, right? And I'm owed something, right? And like there is a view that one could develop where the answer is yes. Like normatively, you are owed some sort of epistemic repair. But that's not what I'm defending, right? The reason I'm fleshing, kind of couching this in terms of gross violations and injustices is because I mean reparations in the sense like that where this has actual political oomph, like, and so, I'm sorry, I've like been working on this stuff for so many years. I feel like there's so much I want to go over. So in the last few years, I have had a grant where we've been engaging in epistemic reparations. And the 3 places we've been doing the work is in South Africa with apartheid-era survivors of apartheid-era violence, in Canada with survivors of the residential school system and indigenous communities, and in Chicago with survivors of carceral injustice. Okay, so we've had a team of collaborators in those spaces, and we've been doing work in those areas. And so, one of the things that, one of the reasons those 3 physical, like geographical locations are really significant is because there has been some overt state or city-led initiative for reparations. So in South Africa, there was the TRC. In Canada, there was the TRC. And maybe this is less well known, but Chicago was the first city in the United States to have a reparations ordinance where survivors of police torture, because Chicago is the police torture capital of the world, receive reparations. So it's an actual reparations ordinance. And Evanston, which is where I live and where Northwestern is the first city in the United States that has engaged in housing reparations for Black residents. Okay? So all 3 of the spaces that we've been doing our work have actual legislation of some sort, right, that has involved reparations. So when I'm talking about epistemic reparations, I'm talking about reparations that would literally be built in to an ordinance, okay? And so for that reason, I'm not saying that there could not be a normative argument made about something that's done to somebody when they're hashtagged or something, but that's not what I'm interested, I'm interested, that's why what I'm talking about are violations that rise to the level of being a gross violation, okay? And obviously there's gonna be some, questions about what that is, but like the UN itself doesn't even actually provide a definition, Okay, so the view is, in cases of gross violations and injustices that involve not being known, I gave you 2 examples, invisibility or vilification, distinctively epistemic reparations are needed. On my view, reparations are epistemic when the goods and the wrongs in question are epistemic. Okay, so that's the view. Sorry, there was a lot of laying the groundwork for kind of a little bit like what I'll stop at 4:30 though. I'm not gonna go on and on. Okay, so I wanna pivot now to a kind of application of the framework, okay? And again, I'm happy to go over more about the framework itself for those who want to hear more. So I want to look at the way that stories themselves can inflict gross violations and injustices on people, and how reparations, kind of stories themselves can also be the source of the corresponding epistemic reparations. So probably unsurprisingly, given some of my other kind of work, I'm going to use as a paradigmatic example storytelling in the criminal legal system. So one of the things that I kind of go over in the book in a lot more detail than I'm going to today is I look at how storytelling plays a powerful role in nearly every aspect of the criminal legal system. Many legal scholars, for instance, talk about how just the law itself is, here Cover says, the law itself is derived from the sacred narratives of our world, and this is not like an anomalous view. But then even moving from the law itself to trials, there's lots and lots of literature on how the role that storytelling plays in trials. So Samuel Gross, for instance, says it's commonplace that most successful courtroom advocacy is structured as storytelling rather than logical proof. Someone else writes, it's the narrative itself that determines a trial's outcome. So just to kind of contrast this, these views are contrasted with views of what happens in trials that says, no, it's not the storytelling that determines the trial's outcome. It's the kind of the probative force of the evidence, right? So on this other view, they're gonna say, it's really just weighing the evidence. That's what determines the trial's outcome. And on this view, they're gonna say, no, it's not. Like, you could have a body of evidence over here that, roughly speaking, supports a verdict more than this one does, but this one has features of good storytelling. It's a coherent narrative, right? it kind of it has a unique explanation of the relevant features, right, and so on. So this is a kind of a substantive claim. Like you might kind of read this and be like, well, sure. I mean, we all have heard opening arguments where it's like, I'm going to tell you about or something like this, right? But this is actually a substantive thesis. It's a claim that it is the storytelling features themselves that really determine a trial's outcome. Now, despite the critical role that narratives play in the criminal legal system, defendants rarely have the opportunity to use their own voices during the legal process. So these are just some kind of quotes. I'm not going to go over all of them, but this is kind of pretty well documented by legal scholars. So I'll just kind of go over a few. So one writes, the United States criminal justice system is shaped by a fundamental absence. Criminal defendants rarely speak. This is the result of a number of factors but I'll just mention one. I mentioned this just to many of you who were in the class earlier today that I visited, that trial by jury is on the verge of extinction in America, with 97.4% of federal felony convictions in the United States obtained through guilty pleas, and state felony convictions not far behind. So against this background of silence, there's an area in the criminal legal system where defendants seem to have a robust role to play in their own destinies, and that's at sentencing hearings. In particular, the right of allocution permits a criminal defendant to speak at his own sentencing hearing prior to the sentencing itself. The importance of this right is clear. In a system where so few people go to trial, let alone testify, sentencing is often the only opportunity for defendants to speak during the legal process in a way that is even nominally unconstrained. But when we pause and think about a defendant who's innocent, we see that the right of allocution can be a further source of victimization. So, for those of you, I kind of document this a bit in the last chapter of my 2023 book. So courts don't want to hear allocution stories of innocence, for instance. Most judges assume, often consistent with the evidence they have heard, that the person before them actually has committed the offense and that any innocence tale is fiction. Now, the mere fact that courts silence innocent defendants and their allocution stories of innocence is problematic by itself. Consider, for instance, the perspective of an innocent defendant who has just been wrongfully convicted of murder. The only point at which he has spoken in the process may have been in the interrogation room when a confession was coerced. After that, he may have been found guilty at trial because of the massive weight afforded to his false confession, or pled guilty because he felt trapped by manufactured evidence against him. In all of the proceedings since the confession or the guilty plea, he has been silent, spoken for and about, but never heard from by the court through his own in real-time voice. He finally arrives at the sentencing hearing and is aware that this is his final opportunity to make a case to the court for justice and mercy. And now he's told that no one wants to hear that he's actually innocent. But the violation doesn't stop here. In addition to being silenced about his actual innocence, the defendant is then essentially provided with a script of what he should say. Judges have archetypes of ideal allocutions in mind. They want the allocution to express genuine remorse, sincerity, realistic and concrete plans for the future, apology to the victims, and an understanding of the seriousness of the offense. So the innocent defendant is not only told to swallow the truth and eat his cries of innocence, he's also handed a script of what he should say to the court. More perversely, he's told impossibly to be both sincere and yet to express life-shattering and identity-destroying falsehoods. He should somehow feign remorse for a crime he didn't commit, one that is often for him unimaginable to have committed, and to utter words that are in the shape of an apology but have no authenticity, as he cannot be truly sorry for doing something that he simply didn't do. But then there is actually even more kind of consequences, because for defendants who maintain their innocence at sentencing hearings, they risk and receive harsher sentences because of their perceived failure to accept responsibility, lack of candor with the court, or failure to acknowledge the validity of the fact finder's decision. I'm actually working on a new paper right now because I end up testifying at a lot of clemency hearings and I testify in front of the Illinois Prisoner Review Board all the time. and at resentencing hearings, because I work with incarcerated people kind of on the other side of the criminal legal system, right, after they've been incarcerated, some of them for decades. And one of the things that just happens over and over and over again is that if there is a conviction of any kind, so the conviction could have been because of a plea, a guilty plea, because of a coerced false confession, because of a true confession, because of a coerced false guilty plea, a true guilty plea, whatever, okay, whatever the case is, there is going to be no relief offered to someone in front of a clemency board or a parole board or at a resentencing hearing who maintains their innocence, no matter what. If the narrative here deviates from the court's narrative, there will be consequences, and so negative ones. And so one of the things that I'm looking at is how this coerced sort of continuity of narrative lends legitimacy to institutions, right? And so because the system basically says, like, before you walk out our doors, you're going to spit back out from your own mouth the narrative that our institution originally documented. And so there is a kind of coerced narrative continuity that we see in these institutions that is providing institutional legitimacy, and this is a part of it. So while storytelling plays a powerful role in human lives, especially in the American criminal legal system, we see that defendants rarely have a voice in their own narratives. This especially impacts innocent defendants who are not only silenced when telling the truth and given a script to follow that is foreign to who they are and fracturing to their moral identity, they also suffer life-altering consequences such as additional time incarcerated for any form of resistance. Now, the violations and injustices inflicted on a person through a wrongful conviction are, of course, deep and multifaceted. In addition to the horrors of being convicted and incarcerated for a crime he didn't commit, the official story about him cultivated, extracted, and promoted by the state is often unrecognizable and demonizing or vilifying. One of the students in the Northwestern Prison Education Program, I think makes this point like really powerfully when he writes, "An extracted false confession creates a false narrative of that person's life. In other words, the extracted confession turns a person's life into a lie. That lie is then believed over the truth of that person's life, victimizing him over and over again. This seems to be the ultimate crime, stealing the essence of someone's life while they yet breathe." And so justice requires, I argue, not only material reparations for something like a wrongful conviction, including release from prison, exoneration, and financial compensation, but also epistemic reparations. In particular, the state's false story inflicts an additional violation and injustice on a wrongfully convicted person, one that demonizes and distorts who he is said who he is, and often who he can become. So one way of engaging in the epistemically reparative work required here is through replacing a false or vilified narrative of a person with a true and respectful one. Consider, for instance, Hilda Lindemann Nelson's notion of a counter story, a story that resists an oppressive identity and attempts to replace it with one that commands respect and positions itself against a number of master narratives. So I want to use this notion of counter story to look at how this would work in the case of a wrongful conviction. So Demetrius Cunningham is someone that I've known for a long time. At the age of 15, he was taken to the police station actually by his father voluntarily because they asked him to come in to view a lineup of suspects. There was a carjacking and a murder in the Loop in Chicago of an elderly woman. And his father voluntarily brought him to the police station, but he was separated from his father. And then he was taken to a room where he was interrogated alone for many hours by multiple white Chicago police officers. A law was passed that would, in Illinois, that would prevent a juvenile from being interrogated like that without an adult present. But when this happened to Demetrius, it was perfectly legal for them to do that. So the officers employed a host of tactics that are known to be manipulative and coercive. And at the end of the interrogation, he falsely confessed to murdering this elderly woman in Chicago. This is Demetrius now. So extending Nelson's concepts, we can understand the master narrative of his life as being the one that was created and promoted by the state. That Demetrius murdered an elderly woman, that he lied about his own actions, that he failed to have the appropriate normative response of taking accountability for his actions and committing to repairing the damage he caused. And this narrative exerts a tremendous amount of epistemic and moral power over the community. It enables them to make sense of their experiences of, say, hatred for Demetrius, to justify incarcerating him, to constrain their imagination over how he deserves to be treated, and so on. I love this picture because this is from a conference that we held inside the prison. One of my colleagues organized it on my 2023 book, where I talk about false confessions. And the students were commentators on the book. So this is actually a picture of him at the conference talking about his experience. And so I just think it's such a perfect picture. So the reparative counterstory here resists this false narrative and replaces it one that is accurate and restorative of Demetrius' status in his community. It not only makes clear the truth about his innocence and the grave injustice he faced through being wrongfully convicted and incarcerated for decades, but also the duty we have to know him for who he truly is. Now, the importance of this particular epistemically reparative work is made even clearer against the background of empirical work on wrongful convictions. So according to a systematic review of research by Brooks and Greenberg, the impact of being wrongfully accused, not even convicted, but just accused of a criminal offense is, quote, frequently complex and long-lasting, with participants reporting permanent changes to their personality, being less confident and more mistrustful, a loss of dignity and credibility, a loss of hope and purpose for the future, a loss of their pre-accusation self, damaged reputations or feeling stigmatized by others, feeling that their standing in the community had been affected negatively, and feeling labeled and vilified by others. Crucially, for our purposes, the authors note that, quote, it was particularly difficult for participants to regain their previous sense of self if they received no formal apology or public statement of innocence, effectively delabeling them. I think this is a clear and compelling acknowledgement of the importance of epistemic reparations in this context. Without a counter-narrative, the victims in question are left not only with the stigma and loss of standing within their community that comes with a wrongful conviction, but also with a damaged sense of self that impacts who they are and who they can become. But harming or wronging another person in a way that demands reparative work, epistemically reparative work, does not necessarily involve having false or even unwarranted beliefs about him. So I want to introduce this concept, what I call misknowing. So misknowing is when only a narrow, one-dimensional set of facts are centered about a person or persons, often focusing on those that are most injurious, resulting in the erasure or distortion of other relevant truths. So misknowing is a form of knowing, but in virtue of its singular or excessive focus on the facts in question, it obscures as much as it reveals. There are many versions of misknowing, but here I will focus on cases where someone is in fact guilty of a crime, but we reduce his entire identity to this one action and regard him as nothing more than, for instance, a murderer. So I want you to meet William Peoples. William admits that he murdered his neighbor in a burglary that went terribly awry in May of 1988, and he writes profoundly about his journey in an article that I'm happy to send a link to that was published in the Northwestern Alumni Magazine. Now today, well over 3 decades later, William is a deeply valued member of the Northwestern Prison Education Program community who mentors those in need. He lifts up those around him. He lives an exemplary life of love and service. And he made history as one of the first incarcerated students in the United States to receive a bachelor's degree from a top 10 university. To know William through the lens of only one, albeit true, action in his nearly 6 decades of life is to misknow him. It is to center one moment in his full, rich life and to relegate features that are now crucial to his identity, such as student, friend, published author, mentor, and visionary, to the margins. It's to allow this one truth about him to squeeze out knowledge of other deeply important truths about William as a person. So what I'm going to do in the next couple of slides is try to convince you that there are instances, it's not true of every criminal defendant in the United States, okay? But what I want to do is point to some systemic forces within the criminal legal system that make the kind of misknowing that I'm talking about in the case of William rise to the level of being a gross violation or injustice. So keep in mind, my view says you're owed epistemic reparations only if the epistemic wrong that you are experiencing either arises from or constitutes a gross violation or injustice, okay? So that's what the next few slides are going to be looking at. So I want to look a bit at the forces that shape public narratives of Americans with criminal convictions. So we looked at what happens at sentencing hearings for innocent defendants, but a guilty defendant is likely to also be silenced or coerced into following a script provided by the court. A guilty defendant, for instance, may quite reasonably feel that it is inappropriate and inauthentic to simply admit guilt, express remorse, and apologize. A guilty defendant may have ended up in front of the judge for countless reasons, including in large part because he is poor or uneducated, or a black male that has been consistently profiled by police, or a victim of abuse or neglect, or addicted to drugs. He may feel that he has been victimized himself by many people and systems in a multitude of ways. In that same Berger-Kaplan article that I cited earlier, one of the defendants that was interviewed expresses this point powerfully. It's tough, right? Because it's like, it's a desperate ass time, and people are probably going to say anything that they can say. It's like, shit, somebody has a gun to your head, and tell me what you want me to say. So as this passage notes, the desperation invoked at a sentencing hearing will drive a defendant to say just about anything, including admitting guilt and apologizing when this is entirely or largely unwarranted. These scripted and coerced allocutions not only contribute false and distorted content to the public narratives of criminal defendants in America, they also lend legitimacy to them. If even the defendant himself admits guilt and shows this much remorse, we are clearly getting things right. The media also contributes to the distorted images, labeling, and stories of many criminal suspects and defendants in the legal system in the United States. This is so well documented, I'm not going to go over this in any sort of detail. I do a bit more in the book. So in a recent report on the role of racial bias in the media regarding coverage of people prosecuted in the criminal court system, it was found that mugshots were used in coverage of 45% of cases involving black people accused of crimes, compared to only 8% of cases involving white defendants. At the same time, white victims were nearly 4 times more likely to be presented in photos with friends and family than black people victimized by crime. The report also found that more personally descriptive words are used for white defendants, while more crime-related descriptions are used for black defendants. White defendants, for instance, were characterized as a father or son or man, while black defendants were referred to as the arrested or accused. In one of the case studies in the report, 57% of the pretrial coverage of this one case characterized the defendant as a serial killer in article headlines, with his name rarely mentioned in them. In general, media coverage was 50% more likely to refer to white defendants by name as compared to black defendants. As the report notes, exclusion of a defendant's name, particularly in favor of a label like serial killer, is yet another way we see defendants, especially black defendants, dehumanized and reflexively criminalized in coverage even before trial. And this dehumanization is exacerbated by the fact that quotes from family members and friends were nearly twice as likely to be found in articles about white defendants than in those about black defendants. Moreover, many aspects of the United States result in people who have been convicted of a crime having their identities largely reduced to this one act. For instance, while crimes, especially high-profile ones, are often covered heavily by the media, like the court TV, it's heavily covered. Rarely do we see similar attention paid to the accomplishments, virtues, and growth of people who are incarcerated. This results in the publicly accessible narratives about incarcerated people often being limited to only their criminal activity. We see the mugshots of people who are incarcerated rather than photos of them in classrooms or hugging their children during visits. We read about their possession of a gun rather than their publication of a work of poetry or leading a restorative justice circle. In addition, prisons are often geographically isolated. In fact, scholars sometimes talk about them occupying the geography of nowhere. The women's prison that we work in, that we try to offer in-person classes to, that's comparable to our on-campus students, 3.5 hours each way from Chicago, right? There are prisons that are 8 hours from Chicago. So if you're, and the bulk of people who are incarcerated in Illinois are from Cook County, right? This means that, family members, well, I could go on and on and on about this. I mean, I'm going to let it go. Okay. In addition, prisons are often geographically isolated so that the institutions and the people inside of them are rendered invisible to most of the public. Communication is highly restricted and monitored within carceral settings so that incarcerated people have very few options for having their own voices heard beyond the bars of their cells. All of this contributes to a systemically driven, unwarranted focus on only the criminal acts of incarcerated people in the United States. This, in turn, leads to them being vilified and distorted as nothing more than, for instance, a cold-blooded murderer. So the misknowing of suspects and defendants is often caused, fueled, and exacerbated by the stories told about them. Despite the powerful space that narratives occupy in the criminal legal system, defendants, whether innocent or guilty, rarely play even a marginal role as authors of their own public stories. They are silenced, they're handed a script to follow, and they're punished severely for failing to follow it. They are then vilified and distorted by the media. They're relegated to isolated carceral settings that are under nearly constant surveillance. They're afforded very few avenues for communication with the outside world. This results in these images and labels and narratives developed and promoted by the criminal legal system and the media, socially locking defendants into these stories, sometimes for life. So just as a wrongful conviction requires a counter-story as a form of epistemic reparations, so too I argue in my new book that misknowing in the criminal legal system requires what I call a rounder story as a kind of epistemic reparations. So E.M. Forrester's famous distinction between flat and round characters is a foundational lesson of many writing classes. Flat characters, according to Forrester, are static and constructed around a single idea or quality, with none of the psychological desires and aches that complicate even the most consistent human lives. A dictionary of narratology defines flat characters as endowed with one or very few traits and highly predictable in behavior. They've been described as monochromatic or one-dimensional, often cast on stage to express a single idea or to serve a specific plot function. They may have some aspect or trait that makes and keeps them interesting or compelling, but what they lack typically is psychological complexity or the ability to change. They are fixed entities and typically do not develop or change in the course of the plot. Round characters, in contrast, are dynamic, complex, and multidimensional, with sufficient information conveyed about their internal tensions, contradictions, and complications so that their actions are understood as the product of several different drives or conflicts derived from more than one level of the personality. In addition to this psychological complexity, round characters are not static, and they evolve or change internally as the plot develops. So in my book, I extend this distinction between flat and round characters to apply to the stories told about them and the resulting knowledge that's conveyed. So a flat story I understand as one that depicts a person in static, one-dimensional, and psychologically simplistic terms, and the knowledge that is then conveyed about him is correspondingly flat. A round story is one that portrays a person in dynamic, multidimensional, and psychologically complex terms, and the knowledge that is then conveyed about him is correspondingly round. As should be clear from what was developed above, many of the stories told about criminal defendants, especially when they are Black, are flat. The media, for instance, center on the one day of the crime, depict the person in a mugshot, avoid the use of his actual name, and label him as the accused, a serial killer, and so on. The criminal legal system then provides virtually no avenues for the defendant to tell his own story in his own words. Once the story of a person's life is created, told, and promoted, the defendant who is convicted is then locked away in an American prison, often in a rural community far from loved ones, with their public narrative similarly locked in time. As far as most of the world knows, he will always be nothing more than that one awful day of his life. So this is a paradigmatically flat story where a person is depicted in static, one-dimensional, and psychologically simplistic terms. I think there's all sorts of epistemic consequences of misknowing. I think there's backward-looking consequences, so we kind of leave out, like we have a very impoverished sense of the events in question without looking backwards. And we also are very likely to make false, forward-looking predictions because we have such limited information. What might a rounder story look like for someone like, this is William at that same conference. In William's case, for instance, such a story should involve recentering his humanity, emphasizing who he has become through decades of growth, pushing facts about the worst day of his life to the periphery. I want to be clear, because some people I think have misunderstood. I'm clear about this in the book. Rounder stories don't have to just be, oh my gosh, you're amazing, right? Rounder stories are targeting the deficiencies of the flat story. So whereas flat stories are one-dimensional, they need to depict people as more multi-dimensional, right? So if you're trying to counter the wrong, the rounder story would be targeting that, right? I mean, one way that I put this, because of course a lot of my work on flat and round stories is motivated by many incarcerated people that I know and love. I think of a flat story as being one where you are a murderer. Normatively speaking, there's nothing interesting about you other than that. So you're a murderer, you're in a way only a murderer, and you will always be only a murderer. So it is static. This is who you are forever. It's one-dimensional. This is all we really care about with you. And it's psychologically simplistic because a lot of the narratives that fuel these kinds of flat stories, a lot of the kind of beliefs that fuel them are much more essentialist, right? Where it's sort of like, you're just a violent person, right? The reason you did this is because you're just violent or you're just evil. So it's, again, this sort of kind of static, very one-dimensional, psychologically simplistic kind of story. In the report discussed above on the role of racial bias in the media regarding coverage of people prosecuted in the criminal court system, the authors provide recommendations for the media. So these are, the reason I actually, this is like one of the last slides. The reason I end with this is because I really like that these are empirical recommendations for the media, but I actually think that they really capture one way of telling rounder stories about people. And I like philosophy to be things that we can kind of understand in our daily lives, right? So they say, the authors provide specific recommendations, some of which provide minimal guidelines for what I would call rounder stories. They don't use this language, but this is how I would understand it. They recommend, for instance, foregoing images that drive perceptions of guilt, avoiding labels that carry negative connotations. In particular, they write that reporters credentialing defendants by crime is dehumanizing, and that journalists should provide quotes from family members, friends, co-workers, and community members, so that they do not remain singularly associated with the offense with which they have been charged, especially in the case of Black defendants. This is an explicit call for what I would call rounder stories in the media of defendants in the American criminal legal system. Okay, I'm going to end. I told you we've had this Epistemic Reparations project for years, so we've been doing a lot of work. So this is a student in the NPEP program, the Northwestern Prison Education Program. His name is Patrick Comey. And one of my graduate students, Mikol, I think her name is on there. Yeah, Patrick Comey with Mikol Bez. She's my graduate assistant on the research project, on the grant that we've had for a few years. And so she did this portraiture workshop with the students on the right to be seen, and allowed the students to take their mugshots and to create an image of themselves that has ownership and agency. And this is what Patrick did, which I just thought was like such a fabulous characterization of taking control of one's sort of story. I mean, in such a simple image, right? It doesn't have to be like a documentary or anything, but just a simple image. So through stories that are both false and flat, people can be wrongfully thought to be who they are not, either because they are not even the proper subject of the narrative in question, or because they are so much more than how they are depicted. At the same time, we have the power to engage in the epistemic reparations called for in such cases through the creation and promotion of stories that counter or round out those that are responsible for the wrongdoing. In this way, though the narratives we create and share can quite literally shape who people are capable of becoming in life-destroying ways, they can also be the path forward for holding one another in life-restoring ways. That's it. Thank you.
Folks, for questions, we have a microphone here that's connected up to the camera. I'm just going to have to move this around the room here and pass on, but Eric, you go first.
Okay. First of all, thank you so much. It was really rich. And so I'm trying to decide which question I want to ask. So let me go with this question, and just a bit of context. When I lived in the Pacific Northwest, I was part of something called the Alternatives to Violence Project that would go into prisons for weekend workshops teaching nonviolence. And these were generally very transformative experiences for the inmates who participated. I used to think about the nature of that transformation in terms of skills development and seeing new possibilities for life. But now, in the light of this, I'm thinking, to what extent is something like epistemic reparations playing a role in what was so transformative in these workshops? Because what was happening is they would come into the workshops, and for a full weekend, they would be sharing themselves with one another and with the outside facilitators, telling stories about their lives, what they loved, what they enjoyed, and playing games together, sharing details of their histories, so that they were basically given an opportunity to tell rounder stories about themselves, right? And that this, I think, take the outside facilitators out of the room, and it may not have had the transformative impact that it had. That somehow we function potentially as representatives, in a sense, of the wider world, although our confidentiality requirements meant that we could never share the stories that we heard, except in a very anonymized form. But that then leads me to wonder, to what extent, there was a hunger for something like this that was being expressed and to some extent being satisfied in these events, or in these workshops. But is there something in your experience that can do this kind of work in a more fully, it's one thing to say, hey, media, don't vilify, right? But the opportunity to share who I am in a fuller, rounder sense. Clearly, in my experience, thinking back on it, made a huge difference in these people's lives. What can be done to increase the avenues for that? If that makes sense.
Yeah, thank you for sharing that and for the question. I have about 1,000 things to say, to pick. So one of the chapters of the book, I talk about what does it mean to be known, in the sense of epistemic reparations. What does that even mean? And I distinguish between two different kinds. One is what I call the bearing witness notion of being known, and the other is what I call the restoring status sense. And so I think that when we are in spaces where we are either listening or co-creating narratives with people, sometimes we're bearing witness, sometimes we're helping to restore status. I think that both of those can function in really epistemically and psychologically and morally. I think there's a lot of different ways in which these can be transformative. So one of the things that I really, in the book, I'm very intentional about encouraging all of us to think of our responsibilities in engaging in epistemic reparations. And so I say it's not one and done, it's a process, but don't despair, because it's like ongoing. We have to do it probably forever. There's a lot to make up for, but it's a collective duty, right? Now, I think it's a complicated picture, because I think there are perfect duties and imperfect duties, and I think perpetrators have perfect duties, and we have imperfect duties that are much more like charitable giving, but you don't want to hear all of it. The point is that I think that there are big and small ways that we can either bear witness or restore status. So I give this as an example to sort of like give an idea of how simple I think it can be. So you know those Nextdoor apps? You know those apps about like where people like report what's going on in the neighborhood? So there's all sorts of empirical work now that the more we have these apps, the more people are like, oh my God, my neighborhood is just like crime-ridden, And it's because, of course, people only report when there's crime. Do you know what I mean? They're like, oh my God, someone was like breaking into my car. So people are like, it's everywhere. And there's a psychologist who like jokingly in an ironic way is like, if only people reported on those apps the absence of crime as frequently as they reported the presence of crime. I actually think there's something deeply interesting about that. So in one of the sections of the book, I juxtapose what I call the creation of rounder stories with like legislation that involves like, which I'm all for these, don't get me wrong, but like clean slate legislation. In fact, Illinois is like right on the cusp of having some really good momentum with respect to clean slate legislation where certain criminal records are erased. The right to erasure or the right to be forgotten, there's like various European countries that have these sorts of rights. That is just the elimination of vilifying stories. So that would be like if we removed William Peoples' criminal history, right? But one of the things I think is really powerful is that with social media, any one of us has the power to share stories and images. I could take this image, I'm not going to because we have to be careful. We might have like art shows and stuff where we show this, but like at some point maybe take this image and just try to share it, right? And like not just erasing vilifying stories, but swamping the singular focus on mugshots with images of incarcerated people with their children or, doing artwork like this, or offering comments at conferences, or and so on, right? And so I actually think that that is really powerful, is doing something just like that, right? Just sharing images, or creating something like this, or and so on. So I actually think that not everybody has to be a documentary filmmaker, right? Not everybody has to be a journalist. Not everybody, I think there are big and small ways that we can engage in epistemic reparations and that all of us should. I hope that answered it a bit.
This was fantastic. I had a question about the kind of first cases of gross injustice. And I wondered if you could say what success looks like in the epistemic reparations. It's complicated, it's ongoing, and maybe it never ends. But is there a kind of a characterization of what success looks like?
Success with respect to what in particular again?
The epistemic reparations. Or is this a case-by-case basis? I guess I'm having trouble thinking of like whether a successful case of reparations, of epistemic reparations, is on an individual level, or if it's kind of population level. Like, I just wondered if you could say something about that.
So I think I'm going to have a little bit of trouble answering that crazily, because I think of this as an ongoing process that's not going to have an end. I'm not really end focused, meaning what is the ideal world? Do you know what I mean? So when we're working in South Africa, for instance, we're talking about like colonialism. Do you know what I mean? Like what? Like where is the end? When are we done? I myself don't find it helpful to even think that way. And I'm kind of clear about this in the book, like that this is an ongoing process, but like don't despair, because literally you can pick up your phone and just share something on Instagram. Like that could be your part today, and then maybe tomorrow it's something else, and maybe the next, So I think that, like, let's take like, kind of flat stories of incarcerated people. I think that rounder stories of incarcerated people would be some kind of success. It would be a step towards some success. We're not done, but again, I'm not thinking about being done. Do you know what I mean? So I think that if there were, for instance, more images of currently incarcerated people that were not their mugshots, I think that that would be progress.
Yeah, thank you for that.
Another question?
Hi, so how do you measure the extent to which injustices have been done, and then how do you in contrast measure how many or how much reparations should be given? If that makes sense.
It does. So I don't think there's an easy answer to this question with respect to any reparations, right? I mean, so when there's financial reparations that are given, right? I think I mentioned, we have a student who came home from prison. He's the longest wrongfully incarcerated person in Illinois. He came home. I start the book that's coming out this year. I start the introduction of the book with standing outside of the prison waiting for him to come out in December of 2023. And he was wrongfully incarcerated for 42 years. He went away at 20 and came home at 62. Obviously he's got, a great law firm. He's going to end up with millions of dollars. But what makes it, there is nothing that gives you 42 years of your life back. He missed out on relationships and family and children and whatever he would have wanted to do, who knows? So I think when we talk about reparations, even in more traditional sense, I'm introducing this concept of epistemic reparations, but all traditional reparations, there's no, I think this is, we sometimes have this model of I stole your car, I had it for 2 weeks, you had to take public transportation for those 2 weeks, let's add that up, right? And give you your car back and the amount of that public transportation and you're whole, right? There is nothing like that when we're talking about the kinds of violations and injustices that I'm interested in. Monetarily, politically, he was unable to vote for 42 years. You can't vote with while incarcerated in Illinois, right? He was denied free, let's go down the list. So his voting rights are restored. I want my 42 years of votes back, right? So I don't think this is just unique to epistemic reparations. I think that when we're talking about how do we make up for gross violations and injustices, let's just use that phrase, we're gonna struggle with this across the board.
So I'm curious how much you think people need to be involved in the collaboration or co-creation of their rounder stories, so that we don't end up in a situation where a really flat story given about them by the state or whatever it may be isn't just replaced with some other inaccurate story that they don't feel like they have agency over or isn't their own. So I'm wondering, how much people need to be involved in that process, right? If somebody's incarcerated and all of us are out doing epistemic reparations by posting about them on social media, whatever it may be, right? We could just be creating a different, albeit maybe more positive, perhaps rounder story that they still feel that they're not an active participant in the creation of. And then relatedly, how do we deal with that when people who are misknown die, right? And then aren't around to participate in the creation of a rounder story.
Yeah. So one of the things that I say in the book is that first and foremost, so I also say in the introduction to the book, I was trained as an analytic epistemologist, so people might be expecting all these necessary and sufficient conditions, and they're going to be very disappointed with this recent book because there are none. But the one time I come pretty close to giving a necessary condition is I say, at a minimum, all epistemic reparations need to center epistemic agency. That's the starting place, right? So do you want someone else to help you tell your story? Do you want to tell your story? Do you not want tell your story? Do you want your privacy? Do you want to be, I have so many anecdotes going in my head when I pause. It's because I'm should I pause to tell that story? But and so that's the starting place, right? Is it does come close to being a necessary condition. There are no epistemic reparations if epistemic agency hasn't been centered. I do have a whole section on epistemic reparations for the dead, and I think it's complicated. I talk about what I call proximate sources. And so for any of you who are familiar with like Brian Stevenson, he's a really well-known lawyer. He has argued many cases in front of the Supreme Court about like death penalty cases. He was the author of Just Mercy. There was a movie made about it with Michael B. Jordan. Anyway, one of the things that he talks about a lot in his work is getting proximate. So he, he's been doing work with people on death row and incarcerated people and work in the criminal legal system for decades. And he talks about the importance of getting proximate, so getting close to suffering, getting close to injustice, getting close to, and the importance of getting proximate. So one of the things that I talk about in the book, and this I don't make a necessary condition, but it's more like a recommendation, that when we cannot, when, like, for instance, a victim is deceased, we should prioritize proximate sources. And proximate sources are sources that were close to that person. So it could be family members, members of the community, members of, that were somehow appointed to this person. This gets tricky, right? I mean, so like Wendy Salkin has this recent book on informal spokespeople, and like she calls, for instance, like Ta-Nehisi Coates, the spokesperson of Black America. Like, is he? You know what I mean? It gets like tricky. Do you know what I'm saying? But like this is, well, because he's referred to that in a lot of articles. Do you know what I mean? That this is sort of the position he occupies. Whatever. We don't need to settle that. The point is that I'm not saying that this is not a difficult question. Do you know what I mean? Is there a proximate source? If so, who is it? Could this person try to hijack the narrative? Of course. All of this could go awry. Some of it could inflict further harm. None of this is problem-free. Do you know what I mean? But this is the world we live in. You know what I mean? None of that is, I think, unique to the framework. I mean, I also get, the worry that some people don't want to be known and they want privacy, and what happens when people expose them, and it's like, people are awful. I'm not writing a book that's going to prevent people from being awful. Do you know what I mean? But it's not part of the framework. I can't give you answers for how to make, not that you're asking, but for people to not be awful. Do you know what I'm saying? So we will have instances where it goes awry, but generally speaking, agency is the most important part of the project.
Thanks very much. Just on the storytelling about and in the criminal justice system, and in particular how trials work, do you think that we ought to be trying to make trials, be more bastions of weighing evidence and, going with the evidence? And if so, do we have any realistic shot of doing that in anywhere like the near-term future, given how the US criminal justice system works?
So it's not like I don't think that the solution is to go with the kind of probabilistic model of how to understand trials or how they should function. But I also think that we do an absolutely horrible job of creating spaces where authentic stories can be told. This is I have a lot of things to say about this, but I mean, it's not effective for anyone, right? I mean, it's there is not evidence that the criminal legal system in America provides healing for victims, right? There's a lot of testimony from victims that, after a trial, even when it's they get a life sentence or they executed, there is no healing, right? There is no closure, right? It's not as though what we're doing is actually effective in any way. And so I just think that mechanisms for better stories, more comprehensive stories, would actually be better for everybody. Do you know what I mean? I think that sometimes victims are not in a space where they want to hear that, and I understand that. Do you know what I mean? But sometimes hearing the story is actually very, very powerful, right? And having that connection and understanding about what happened or how these things unfolded can be very powerful for everybody. And so I think just in general, the whole way that the system is set up, where defendants are, it's advantageous for them to just be silent or to be dishonest sometimes. I mean, there's like a real motivation to say, I didn't do it, rather than space where people can recognize, like, I'm gonna take ownership of my role in this, but that doesn't mean that the system is then gonna just come for me. I mean, the system is just, there's so many layers of how, things we would need to change to be able to get to a space where more authentic stories can be told. So there are a lot of initiatives now to have restorative justice options. In the United States, we're a long way off from that being instead of the criminal legal system, certainly in the case of adult violent crimes. But there are a lot of initiatives that are trying to promote that more after sentencing, you know. Of course, I think that's great for human beings, but it doesn't help the defendant in any way in terms of his sentence. He might still have a life sentence. You know what I mean? And you're not even gonna believe this story. Illinois started, it was partly an initiative of the Lieutenant Governor's office, and they involved the state's attorney's office in a trial restorative justice program. One of my students participated. And so the idea was, you write an apology letter to your victim and it gets put in a bank. And then they let the victim know that there's an apology letter for you in the bank, and you can kind of opt to see it and then opt to make a connection. And so my student wrote an apology letter, and and he has some issues going on in court, and the state's attorney's office took it, and this was supposed to be one of the foundational tenets of restorative justice work. The state's attorney took it and was like, oh, he's apologizing, but he claims this was self-defense. We're gonna go for first degree now.
Oh my God.
Unbelievable, unbelievable. And he never said, I'm sorry for intentionally, it was like, I'm sorry for the harm, I'm sorry. Everything that the restorative justice program was like accountability, and it was incredible. I mean, I actually went to the Lieutenant Governor's office, complained about this. They went to the state's attorney's office and told them so, and the program has been paused. The whole RJ program has been paused. Well, this is you can't have this as an option. Like, the state's attorney's office cannot have access to those letters. And one of the things that's supposed to be absolutely unequivocal is you should not participate in these programs if you have any potential action in court. That's a tough one, because sometimes you get a lawyer down the road who's like, I have new evidence or something. Do you see what? So it's tricky. It's very tricky. But in general, those like apology letters in a restorative justice practice should never be weaponized in that sort of way. Anyway, sorry, I digress a little bit.
Dr. Lackey, when you're talking about examples of individuals that have been wrongly imprisoned, such as your acquaintances, then John Grisham wrote a book. His first nonfiction book was about an innocent man who spent 11 years on death row in this state. No matter the time frame, if evidence comes to light, that person's released, I don't think you'll never put that person back home. You've made that point, and I think we all would all agree. But at the same time, I don't think you would ever get any pushback about any financial help or reparations that person deserves. But when you're talking about apartheid, or the Jews in the 40s, or the Khmer Rouge regime in Cambodia in the 70s, now you're talking about large groups of people. At what point does the present society not have to be responsible for reparations that happened so long ago? Do you address that in your book?
So in a way, because I think that it's all, I move away from an act-based approach to a process-based approach. I don't think that there is an end in a way, right? And I know that that's an uncomfortable truth to sit with, but I try to make it more like I try to invite people into this space through the examples I give of the kind of processes we can be engaging in, right? So keep in mind, the book itself is not about like material reparations, right? So I'm talking about epistemic reparations, but I think that when you are talking about something like, systemic racism or colonialism, there are going to be ongoing wrongs and harms that are ongoing, right? And that the reparations have to be similarly ongoing. I don't really know of any reparations framework that talks about this. It's very act-based kind of, tends to be a very act-based sort of framework, right? And I think that it is helpful to think about these as processes because wrongdoing doesn't end when people have moved on. Do you know what I'm saying? Like a war has ended or a genocide has been officially declared over or something like that. So.
I think it's a collection of a lot of things that you address, even the journalism aspect of, how we're presented something. And look at Joseph Goebbels. I mean, he was a master at convincing people this is the way it is. And to an extent, a lot of journalists do that today, especially when they're reporting on crime. And you've always heard that, the bad stories sell. It's those feel-good stories like, for instance, the successes that some of your acquaintances have achieved. Those are feel-good stories, and we need to see more of that. But I don't know about journalism anymore.
So are you worried that those aren't gonna they're not gonna be as captivating? Is that the worry? Yeah, I think we need to get better at telling those stories. I mean it, I just think we need to get better at telling them, I mean, I think that I'm not a journalist and I'm not a storyteller, but there are some kind of genres online. I also don't spend a lot of time on social media, I have to tell you. So this is mostly from my 20-year-old kids. But because they send me TikToks all the time and I'm just like, what, But there are spaces in those social media places where feel-good stories do seem to do well. So look, I'm thinking about some of these blogs about families, right? That'll have millions of subscribers. You know what I'm talking about? Where it's just family life. It's just fun family life. Look at my kid is crying and I don't know. I don't watch them, but I know they exist. Do you know what I'm saying? So I do think that we need to think about how we are better. You're right, the crime, the appetite for crime stories seems sort of insatiable, right? I mean, it's the reels and stuff of current crime, courtrooms, and it just seems and how do we tell similarly captivating stories about good things? I mean, I think that is a good empirical question, Yeah.
All right, folks, we're about out of time now. If you could please join me in just thanking Dr. Lackey again for being here with us. We'll be around for a little while longer if you have any further questions for her. All right, thanks for coming.